What I'm going to be talking about or focusing on today are lawsuits against accused persons and the problem of evidence. And I refer you to the proceedings for a quote from one of the earliest repressed memory cases against parents, the Tyson v. Tyson case that was heard by the Washington State Supreme Court. This particular decision has been superseded by state statute, but is still one of the most often cited decisions because of its discussion and anticipation of questions related to evidence in lawsuits against parents. The False Memory Syndrome Foundation Legal Survey Project now has information on nearly 800 repressed memory lawsuits filed in the United States. It is by no means assumed that this represents the total number of such suits that are out there. Approximately 90% of the repressed memory claims have been brought against accused persons in civil court. The remainder are criminal actions. This information regarding these nearly 800 repressed memory lawsuits comes primarily from accused persons and from attorneys who have contacted the foundation and from published decisions of higher courts. The Legal Survey Project follows up with requests for information and court documents and sends out written survey forms. That survey data now includes considerable detail on the facts of individual legal claims, information on resolution in approximately 1/4 of the cases tracked, published decisions in approximately 120 cases, and a growing collection of motions, filings, and so forth, representing the relevant psychological arguments and the points of law which arise in many of these cases. The Foundation has published from these materials several important resources for attorneys and for families with legal questions. And they're described on a pink page that you can find at the table just outside the rear door. And these we really want you to take home, take a look at, show to your attorney. It's a good description of that information. If we do run out, leave your name and address and we'll send it to you. Any review of this growing set of cases shows how repressed memory lawsuits presented in courts have shown an increasingly complex category of evidence and testimony from which they are to make a decision. And one reason why this might be is suggested by the FMSF legal survey results. The most striking findings from that survey of nearly 800 lawsuits are that 1, repressed memory lawsuits can be characterized by an absence of factual corroboration for the allegations themselves, as compared to testimony regarding psychological effects of the alleged abuse and so forth. 2, when a review of the claims filed by plaintiffs is done, it shows that the majority of the claims are based on memories which arose in therapy, and that there was no memory of such abuse prior to therapy. To date, the majority, this is the third point, and this is an important one, to date, the majority of repressed memory lawsuits are resolved when they are dropped by the plaintiff, dismissed on summary judgment, dismissed on merits, or are resolved with a finding for the accused defendant. These are the basic characteristics and the most frequent outcomes of repressed memory claims at trial level. One might ask whether the higher courts have taken note and have provided direction or guidance to whether higher courts have taken note and provided direction or guidance to trial courts on how to handle these cases. If you have looked at the Tyson quote, that reminder that objective support is required to determine the facts of the case has been specifically taken up in over half of the states where a higher level court has reviewed application of the discovery rule to child abuse cases. However, a clear definition of the kind of evidence the courts accept as objective support of such a claim has not been forthcoming. Where there has been a lack of objective evidence, courts have considered the admissibility, the weight, the credibility of testimony offered by the plaintiff, and also of expert testimony about, among other things, the reliability of the memory process or memory recovery process, and the authenticity of post-traumatic symptoms. This review of published decisions from higher courts, which considered trial court rulings on applicability of the discovery rule, has indicated that most, in fact, found it necessary to remind the lower court that the plaintiff still bore the burden of proof, and bore that burden to prove two things: that repression and discovery had occurred so as to toll the statute of limitation and apply the discovery rule, and independently to prove that repression and discovery yielded accurate memories of actual events. Many higher courts have expressed concern about the reliability of repressed memories and the process of recovering such memories. And they cite many of the studies that we heard presented at the conference today. They also voice concern that victims of child sex abuse be allowed to bring a claim which may be fairly considered. Many of those decisions which discuss the plaintiff's burden to prove the actual event warned the courts to distinguish between objective and subjective evidence, but have declined to stipulate guidelines. The problem of evidence in repressed memory cases may stem partly from the fact that it is used to different effect in discovery rule hearings to toll the statute of limitations and in the courtroom where the facts of the case are being tried. The majority of the higher courts have accepted, and some have required, affidavits by mental health professionals supporting the plaintiff's claim of repression and of subsequent discovery under the statutory provisions or parameters in order to apply the discovery rule. In many jurisdictions, it remains to be seen whether such affidavits will be applied to corroborate the repression discovery claim, or even the claim of abuse itself, or only to raise a trialable issue which the trial court is ultimately to determine. Some courts have explicitly acknowledged that affidavits from a therapist are based on what the plaintiff has said and not on new information, and have therefore urged admitting it with extreme caution. One new area to watch is the possible application of criteria for admissibility of scientific evidence that comes from the U.S. Supreme Court decision, Daubert v. Merrill Dow, and the application of this decision to repressed memory cases. Daubert interprets the federal rules of evidence and provides guidance about judicial use of scientific testimony. The U.S. Supreme Court ruled that such testimony must be judicially relevant and scientifically valid. In defining validity and reliability, the High Court attempted to establish what science would have standing in a court of law. To be admissible, a scientific theory should be testable and falsifiable, capable of meeting peer review, and if involving a methodology or process, have a known rate of error. The handful of cases where the Daubert criteria has been offered in repressed memory situations suggests that a new challenge to the admission of expert testimony regarding post-traumatic symptomology and dissociation, repression, and memory recovery. Where a plaintiff had no memory of abuse prior to recovering images of therapy, the plaintiff's testimony will also be challenged under Daubert. The Foundation has in its brief bank filings from 3 repressed memory cases, 2 criminal cases heard simultaneously from New Hampshire, and 1 civil case from Massachusetts, in which the Daubert analysis was applied to restrict either the complainant's testimony or the expert testimony as to the complainant's claim of repression discovery and symptomology. The New Hampshire Superior Court, in 2 cases heard less than 3 months ago, stipulated that the state, in order to introduce the complainant's testimony, must show that it met the Daubert criteria of reliability and validity, and a second hearing is scheduled in the near future. That court held that the concept of repressed memory and its recovery through therapy is clearly a part of the scientific process, and the court drew a parallel to the long history of case law restricting the admissibility of testimony based on hypnotically refreshed memory. To make a long story short, Courts in most jurisdictions have been very cautious in admitting such testimony from hypnotic sessions. Admissibility has most frequently been determined by an analysis based on the reliability and general acceptance of the scientific process of hypnosis, of which those enhanced memories are a product. In this repressed memory case, the New Hampshire court specifically stated that before testimony of the victim's memory of the alleged assault may be admitted, a hearing shall be held at which the burden shall be upon the state to establish that the phenomenon of memory repression and the process of recovery through therapy has gained general acceptance in the field of psychology. The state must establish that the validity of the phenomenon and the process must establish the validity of the phenomenon and the process by demonstrating that the reasoning or methodology underlying the testimony is scientifically valid, and that it is capable of empirical testing and can be properly applied to the facts in issue. It remains, of course, to be seen whether courts will generally follow this analysis, and it certainly is an area to watch. The FMSF brief bank also includes motions from a recent Massachusetts repressed memory civil case. That case was brought by a plaintiff who alleged no memory of abuse prior to therapy. Defense moved to restrict the plaintiff's testimony and the expert's opinion and based on a Daubert evaluation of the reliability of those memories, the memory recovery process, and the theory from which it is derived. The case was dismissed only a few months ago. In two other recent cases, the Daubert guidelines were applied to determining reliability of expert testimony offered in the form of syndrome evidence related to child sexual abuse accommodation syndrome and to post-traumatic stress disorder. In one case, the offered testimony was found inadmissible on the basis of Daubert, and in the other, while admissible, the testimony could not be used to establish the victim's credibility. To conclude, it seems that repressed memories by their very nature have forced the courts to consider increasingly complex categories of evidence when trying to decide whether to apply the discovery rule or when deciding the facts of the case. And recent landmark decisions on scientific testimony have provided guidelines that may result in more stringent application of the admissibility test for plaintiff and expert testimony about recovered memory and of the